Hello, everyone. I hope you all have had a chance to grab a bite to eat. We're going to go ahead and get started. I'm Suzanne Wunz. I'm the Executive Director of the Harvard Law School Library. And on behalf of the library, I'd like to thank you all for coming to today's book talk. Professor Ramseyer's latest book, Second Best Justice, The Virtues of Japanese Private Law, which is so hot that it's not even quite off the presses yet. So there are flyers, and they have a 20% coupon on the back for ordering. So after our panelists pique your interest, you can go place those orders. And I'd like to thank the Dean's Office for the lunch today. And I also just wanted to let you know that it is being recorded, and not live streamed, but it is being recorded for future viewing. And so at the end, when we have time for questions, if you ask any, the audio will also be part of the recording. And to make sure that the questions come through nice and strong, we'll be using this mic during the questions as well. So without further ado, I will introduce our panelists. First, we have Professor Mark Ramseyer, our author. Professor Ramseyer is the Mitsubishi Professor of Japanese Legal Studies here at HLS. And he is joined today here by Professor Richard J. Samuels, the Ford International Professor of Political Science and Director of the Center for International Studies at MIT, and also Founding Director of the MIT Japan Program. We also have Professor Alan Farrell from HLS, who is the Harvey Greenfield Professor of Securities Law. And finally, we have Professor Theodore J. Gilman, who is Executive Director of the Harvard Weatherhead Center for International Affairs. And without further ado, I'll hand it over to Professor Ramseyer.
Thank you. It's incredibly flattering to see everyone here, to see Dick Samuels, Alan Farrell, Ted Gilman here to talk about my book, which isn't even directly in their field. I mean, this is just I'm very kind of them to come, and I'm really humbled by this. I'm also humbled by the fact that all of you are here. This is not a free lunch. You have to listen to a discussion of my book. So thank you very much. I'm incredibly flattered. But I would like to hear what Dick and Ted and Alan have to say. So I don't want to take up too much airtime, but I know the rest of you, since the book isn't out, haven't seen it. So I thought what I would do is take 10 minutes and tell you what the basic argument is, and then listen to the real experts here on what I did wrong. Here's the basic argument. It's that the Japanese legal system works pretty well. It actually, in significant ways, works better than what we have. And it works pretty well because Japanese judges don't try as hard. That they don't try to get things exactly right. They make do with things that are about right. And in some significant ways, legal systems work best if you don't try too hard, if you don't try to get something that is precisely exactly right. And this is what my friend Richard Epstein at Chicago used to call Blum's rule after our late colleague Wally Blum. And the way Wally Blum put it was, in law, 95% is perfection. At a more pedantic level, you can call it the theory of the second best, that if you can't get exactly what you want on one dimension, you will often do better if you don't try to get exactly right on all the other dimensions as well. And the dimension on which we have the problem here is that this is a legal system with human beings, and we're trying to reconstruct the past, and we obviously can't do that. We weren't there. Judges weren't there. And there are some witnesses, but people forget. And they have biases in their evidence, but it's selective evidence because people sort of arrange to have certain things survive and other things not survive. Sometimes it's random, sometimes it's biased, but certainly it's not complete. And so we will never get a precise understanding of what happened. And that makes it hard to try to continue to do right on all the other dimensions, such as valuing human life precisely and doing justice in the abstract, et cetera. All of which is far too abstract discussion. So let me give you one example which I think captures this best, which is traffic accidents. There are a lot of traffic accidents in Japan. There are a lot of traffic accidents here, but it's much less likely that a traffic accident in Japan will end up in court. And the usual suspects don't explain it. It's not that Japanese courts don't value human life as high as American courts. If anything, they seem to value it slightly higher. It's not that Japanese courts are slower than American courts. If anything, they're probably a little higher. And it's not that attorneys cost more, because, again, they're probably cheaper. And so what are Japanese accident victims doing? The answer is they're collecting. They are regularly, if it's a serious traffic accident, they're almost always collecting amounts. They're collecting them out of court, and they're collecting out-of-court amounts that track really closely what they would get if they did take the dispute to court. So they're collecting large amounts, they're collecting them expeditiously, and they're collecting them without paying the huge toll charge that you have to pay in the US in terms of attorney compensation. So why are they able to do this? They're able to do this, I think, because they're acting as if they're bureaucrats. So they're not trying to do justice, although they will obviously tell you they're trying to do justice. They're trying to fit a formula and clear the paper off their desks. And that works out to be a much, I think, in significant ways, a better way of doing all of this than somehow trying to do justice in an abstract sense. So for example, somebody dies in a traffic accident, you have to value the person's life. How do you do it? In Japan, you just pull out a table. You have sex, you have age, you have earnings, you go down, there's your present value, expected life. You cut out half for cost of living, add a set amount for pain and suffering, and boom, that's it, okay? You can get these tables off the web, you can buy them in the bookstores, anybody can get them. And if judges regularly follow them, then there's nothing to, there's no reason to ask a judge to value human life, because this is what you're gonna get. So you might as well save the attorney fees that you would have to pay otherwise. You add pain and suffering, but pain and suffering is a set amount. So is any of this fair? Well, it's usually about right for ordinary human beings, right? I mean, ordinary people have about ordinary value, given these various parameters which you would put in. You will not award enough to a whiz kid in college who would have become a vice president at Goldman Sachs within 5 years. You'll pay too much to a college student who's a deadbeat and is basically inherently unemployable. But on average, you'll get it about right. The pain and suffering will be too low for somebody who really had an excruciating 5 minutes before he died. And it'll be too much for somebody who doesn't remember, who was never conscious of the accident. But on average, it's about right. And then remember in all of this that before you came to law school, the notion that you would put a dollar value on human life and pain and suffering sort of seemed vaguely odd anyway. And what you have in Japan is a very mechanical way of dealing with this. And then sort of take another big part of traffic accident litigation, which would be fault. Japan is what we call a comparative negligence regime. And how do you assign comparative negligence amounts if you're a Japanese judge? You pull out your book, and each page is a diagram. And it's got white car coming in, blue car coming up. Black car turns in front of white car, they have a crash, and then there's a number at the bottom. 80-20, 30-70, it's all right there. You adjusted it for the time of day, for the speed at which the cars were traveling, and so forth. But you just have a whole series of these things. And you can order them off the web if you want to have them yourself. So it's easy to find out. And again, if judges follow them, there's no point in asking a judge to decide all this stuff. You might as well save your attorney's fees. So why is it that Japanese judges are able to do this? I think they're able to do this because it's a career bureaucracy, and they're really busy. And it's not that these things are legally required. If you read the civil code, it will just tell you you're supposed to pay somebody's damages. It doesn't tell you how to calculate those damages. It certainly doesn't tell you anything about following tables and charts and figures for relative fault. Those are all things put together by a committee of judges who thought it would be helpful to have, right? But Japanese judges are hired straight out of law school. So you don't have much information about them. It's not like you have a middle-aged corporate lawyer who has a track record of being a workaholic and of being of a certain IQ level that you know. These are students just out of school. You don't know which are deadbeats. You don't know which work hard, except that they were able to pass this test. And so you have to monitor them, and you have to give them incentives. And the Japanese court system basically has a couple of very strict incentives. One is pay. Okay, the Constitution, which we wrote, Americans, says you can't dock a judge's pay, but it doesn't say you have to move them up the pay scale at the same pace. And if you're hiring somebody at age 25 and somebody else at 65, there are plenty of reasons you wouldn't want to have the same pay. In fact, the pay goes up by a multiple of 10 from the bottom to the top. So it's a huge range. And the court system has judges whose job it is to monitor other judges and decide how fast to move people up the pay scale. Right? So that's part of it. Another part of it is moving judges around. Judges get reassigned every 3 years, and they're moved all around the country. Parts of Japan are places that judges want to live, and parts are places where nobody would want to live other than Americans who think it's really neat to be out in fishing villages along the Japan Sea. But you can move people around, and the Central Personnel Office will move people around depending on how they perform. And so what is it that they're looking for in judging this performance? It's how fast are you clearing paper, and are you doing it in a predictable, routinized, ordinary sort of way? You got a job. You have a lot of traffic accidents. You got a lot of debt collection disputes. Can you get this stuff out the door expeditiously? And if you're going to do that, then you don't want to mess around trying to hold hearings on whether this person's life was really worth X rather than what you get on this table. You follow the table, and it's fast. Nobody's going to give you grief at the Central Personnel Office. And the result is that disputants are able to resolve these disputes very fast and without attorneys. And so you're not paying the toll charge. You're not getting something that's basically individualized justice. You're getting standardized stuff, but you're getting it at a much lower cost than here. And so that's the story. I have a chapter where I apply it or don't apply it, sort of tell you why it applies and why it doesn't apply to products liability. I do the same thing with medical malpractice. When judges are mechanically following these what comes before, you end up with not just law that makes sense being perpetuated, but also law that really doesn't make any sense at all being continued. And I discuss this. I mean, there is a sense in which, ironically enough, precedent binds more tightly in civil law Japan than in the common law US, I think, for reasons of these bureaucratic incentives. But that's the story. So thank you, everybody, for being here, and thank you, Dick and Ted and Alan, for agreeing to respond to this.
Terrific. What order shall we?
Just run the table here? Yeah.
Oh, okay, we'll run the table. Great. So I very much enjoyed reading the book, and found it, if you've read Mark's work in the past, you will, I think, also find it characteristically well-researched, pointed, myth-busting, and pleasantly quirky. This is Mark. It's really what one comes to expect from him, and that's why I always look forward to reading what he's written. As he said, he's gone to take some pain to explain the famously non-litigious, that the famously non-litigious Japanese are anything but that, that they do not hesitate to seek redress for tort claims, that they just do it outside the courts. You've just heard a bit of the argument, doing it in the shadow of the law, in a sense, and it's about incentives, as Mark just laid out for us. It's about incentives, incentives that lead them to lower their expectations for what will be delivered by way of justice, and thereby rewards them along the way with a more transparent, more uniform, more predictable results. All that is the stuff of the argument. And now, as Mark pointed out, maybe defensively, maybe offensively, I'm not sure, as preemptively, I'm not a lawyer. I'm a political scientist. I'm not a legal scholar. I'm not an economist. But I thought what I'd do is use my 10 minutes here to explore this issue of incentives, because it comes up throughout the book and is of particular interest to all social scientists, I think, across fields. and to talk a little bit about how Mark deals with incentives. And I should also add that I'm not a sociologist, and the reason for my saying that will become evident in that declaration. The reason for the declaration will become evident in just a moment. Now, what Mark does is slay dragons here, and central to the dragons that he slays, and there are many lying on their sides throughout this book, which is why the book was fun to read, are the widely embraced conventional claims that culture governs the behavior of legal institutions. You know, stick a fork in culture, it is dead in the Ramseyer account. Now, not to put too fine a point on it, maybe I already did, but he's got no use for it. Got no use for culture. Others will see norms at work. He sees incentives or dismisses stereotypes, but sees basically incentives. And it's a familiar approach by now, and it's an important one. It's that institutions shape incentives, and incentives shape behavior, and we're familiar with it across the social sciences, out of economics to law to political science, and elsewhere as rational choice. So, you know, constructivists in the audience, forgive me, I don't know if there would be any here necessarily, but I do think he's right. I do think he's right, mostly. But I also think that Mark's St. George is a tad too ambitious, and in the use of institutions, a little too dismissive of norms and their capacity to affect behavior. Because I thought, as I read the book, even in his own account, norms are pervasive in the Japanese legal system. So I want to try to work through some of the ways in which I saw that, and maybe he can correct me and say, I misread, that's not what he was saying. But I thought the best example of all of this came up in the issue of Japanese labor law, which is one of his cases, a really important case, but not one of the ones that he mentioned in his, so it's nice, we'll have a little bit of, we'll give you the full range of the book as we go through this. But it's where the courts accepted norms of lifetime employment and baked them into their decisions regarding dismissals and hiring. He reminds us the so-called lifetime employment system of Japan was built on a mountain of sociological fiction in Japan. And he's correct, it was. He dates it from, you know, this is a small nit to pick, but he dates it from Jim Beglin's doctoral thesis in the 1950s. But on my reading, that mountain was first scaled. Oh, you don't scale, you know, I'm talking about building a mountain, so it's first piled up. I thought at least 2-3 decades earlier, in the 1920s, when the Japanese, the umbrella idea for it, corporate paternalism, was first invented and then invoked by Japanese business leaders, a strategy really by industrialists who wanted to prevent Japanese trade unions from organizing along the lines as they had in Europe in the 1920s. And you know, either way, the point is that a fictional culture, this fictional mountain, was invented and then deployed rationally to shift incentives and thereby national outcomes. And I think that understanding that is thanks in large measure due to, dare I say, two sociologists, Ronald Dorr, who wrote about this first, and then Robert Cole, at the University of Michigan. So we've known about it for years, and I think it's a great example of culture deployed as an instrument, and Mark verifies that in the realm of policy and legal outcomes. But while he elides culture altogether, I think on his own account there's cultural intermediation aplenty in the story, and I want to get at that. So the courts, for example, my reading, embraced the fiction that had come to be embraced in Japanese society at large, which is it interpreted the law to ensure that it would be extremely difficult to fire regular workers. Regular workers is a term of art, seishain in Japanese, regular employees. Contrary to his claim, I thought, that no firm ever promised lifetime employment. He makes this claim, no firm ever promised lifetime employment, either explicitly or implicitly. Lifetime employment, on my understanding, was indeed the expectation of workers during the post-war high-growth period at least, and probably earlier and later. But I think, I haven't done this, I probably should if I'm going to attack him on this, but you know, any opinion poll, I think, would reveal that workers believed that they had entered into a tacit bargain with their firm once they became, say, Shahin. Now, even if it had never become law or enshrined explicitly in a contract, lifetime employment was protected, came to be protected by the courts. As he says, the notion had passed beyond its origins, these are Mark's words, to its current place in the pantheon of taken for granted national stereotypes. That's as close as he gets to norms and culture, it's stereotypes. But if the courts were defending it, I think it deserves to be conceived of as more than a stereotype. Again, it seems to me this is the essence of what a norm is, and while it just seems to me that when the courts rule that norms trump contract terms, which is what we see in this chapter repeatedly, then clearly we're dealing with something more than straight up institutional material incentives, it seems to me anyway. And this, of course, is reversed when we see how non-regular workers are treated by courts in firms with different hiring standards, different terms, different hours, different pay scales, a classic case of economic incentives trumping norms. It cuts the other way. In fact, really destroying norms, if you're willing to accept that there were norms to begin with. And here we're again in the realm, now we're in the realm of strategy, purposely building up this non-regular worker sector in order to destroy norms that had encrusted and made difficult the flexibility that the Japanese employers wished to achieve. And then there's the recognition that firms are reluctant to hire women on the regular track, and the observation that the percentage of women on the temporary track is higher than the percentage of men there. And there's no disputing the data, but Mark attributed it in part, he said, those are his words, in part, to differential preferences regarding child rearing by employees. Now, as anyone who's worked, and surely in this audience, more than several probably have, in Japanese firms, you know that the differential preferences also reside in the human resource offices of these companies, which routinely release women when they become, at least did, released women when they became pregnant or when they got married or when, God forbid, they married other workers in the same firm, the shokuba kekkon, the workplace marriage. So the fact, it seems to me, that the percentage of women on the temporary track has expanded much faster than the percentage of men suggests other kinds of gender biases beyond the choices that they make about child rearing that Mark, I think, grudgingly acknowledges. Again, maybe it's culture. Maybe it's not. There's another datum that undermines, and I'll try to move more quickly here, but undermines explanations of economic rationality, at least strict explanations based on economic rationality. And that's that, as he points out, economies with more regulated labor markets have employees with longer tenure and have slower growth. Now, I don't understand why regulators should bake in slow growth into their economies unless they were pursuing a differential kind of rationality here. And if so, aren't different values possibly the source of those different choices? And we can talk about this if we have time during Q&A. There's some wonderful examples here in the context of what the Japanese like to refer to as excessive competition. He also notes that urban dwellers are more litigious than their rural cousins, an explanation that's linked to the presence of more sophisticated hospitals that take on more difficult cases with the greater likelihood of bad outcomes. So the Japanese are likely to sue their best doctors and rather than their worst ones. And this was really, I thought, fascinating. This is very interesting. But it's actually a second order explanation. Again, if we go to the incentives, his primary one seems plausibly sociological to me, which is that the higher the quality of the hospital and the skill of the physicians, the higher level of care the court would demand. And he cites a 1995 Supreme Court ruling that explicitly claims that a uniform standard cannot be imposed on all medical institutions. Their character, the area in which they're located, have to be factored into award decisions. Again, this seems subjective to me, the opposite of what at least I, as a non-practitioner, would expect from a uniform legal code. There's an attribution of overwork-related suicides to limits imposed by the courts on dismissals, which struck me as, I have to say, which struck me as a bit like blaming the police murders in Ferguson and in Baltimore and in Staten Island on police training manuals. I mean, there's a lot of intermediation, cultural intermediation between those rules and those outcomes that I think are being elided here. So while I'm happy to stipulate that Mark offers an important corrective to rebalance to purely sociological explanations, I think he himself has introduced limits that are worth discussing, and I think there's a greater room for ecumenism here, for the possibility that norms can shift preferences not unlike the way that institutions do, or at least that they might. Thanks very much.
Thank you.
So I'm an economist and work in American law largely, and so I'm going to take that perspective in my remarks. First of all, it's a terrific book. I actually had the pleasure over the years of seeing some of the papers that the book is based on presented, and so it's great to see this research put together and see the larger themes coming out of his work. So my takeaway from the book, and I don't mean to put words in Mark's mouth, but my takeaway is incentives matter, that people are people, and that if you want to understand the outcomes of a legal and institutional regime, you have to understand the incentive regime under which they operate, rather than vague references to culture. And maybe in this regard, he's preaching to the converted. I find that extremely helpful and a clear framework. And so I love that about the book. And also not just as a descriptive matter, but also normatively. So you can try to understand some of the properties of the incentive regime that's created and think about things from a policy perspective as well. Now, another takeaway that I got from the book, and it runs throughout the different chapters of the book and was touched on a little bit in Mark's opening remarks, is the allocation of talent and resources and how that's affected by the incentive regime created by the institutional and legal structure. So maybe the U.S. puts, and Harvard Law School might be a beneficiary of this, but maybe the U.S. puts too much, allocates too much talent and resources into the U.S. legal system in figuring things after the fact, figuring out what happened after the fact, as opposed to something more like the Japanese system where you just have, on average, what would we expect. Let's not try to reconstruct the past in any particular case. And I saw that as maybe the most important theme of the book. The way I thought about this issue was, it depends. It depends on how much the level of resources that we want to allocate into the legal system and reconstructing the past and tailoring the decision to the particular facts and circumstances depends on what we believe about the world. So if I'm driving a car and I'm driving recklessly, but I don't know the level of harm that I might cause, I might kill the whiz kid or I might kill the deadbeat, I don't know, then it might make sense, I'm simplifying here, to just do an average of the two or the average of the possible outcomes. And then that would create the optimal incentives, because even though I'm going to create a certain level of harm that could be figured out ex post, I'm going to respond to, I don't know the level of harm that I'm going to cause. And so an average might do the trick. And therefore, the US system, at least in that scenario, doesn't make a lot of sense, the allocation of resources. Another scenario might be that I'm driving my car. I know exactly who I'm going to kill if I kill anybody. Maybe I'm driving near the University of Tokyo and I know there's a lot of smart people around. So I have some idea of the level of harm I'm going to cause, but maybe I can't anticipate what the court system's going to do. Maybe it's in the US, it can be very difficult to know what the outcome's going to be, given the idiosyncratic, all the different things that can happen in litigation, given the fact that you're trying to reconstruct the past. And so in that scenario, just being very simplistic here, again, it might make sense just to do an average, even if I know the level of harm that I'm likely to cause. Another scenario would be, okay, I know the level of harm that I'm going to cause by my conduct, and I can anticipate what the court's going to do, but the courts are going to get it systematically wrong. So again, in standard law and economics framework, this is not original to me, but in the standard law and economics framework, that's going to create, the US system's not going to make sense as well. And then we finally have our last scenario, which would be, I know the level of harm, I can anticipate what the courts are going to do, and the courts are going to get it right, or at least largely get it right. I'll leave it to you to make a judgment about how plausible that is in the U.S. in different contexts. And in that scenario, the U.S. system might make sense, but then we have to weigh the cost of litigation versus the incentives created by an average penalty. So this is a long-winded way of saying is Mark's contention about an average, just doing things on average as the penalty rather than getting into something highly tailored seems very plausible to me. I guess I would push Mark, if I was going to push Mark, a little bit about, of these different scenarios, and there's variations on those scenarios that you can do. You can introduce risk aversion, all sorts of other things. What does he think the key scenario is that makes the Japanese system, at least in a lot of contexts, better than the U.S.? I want to finally end with my favorite example from the book about allocation of talent and resources to sort of encourage everybody to read the book and see some, and see all the different scenarios or contexts that Mark talks about. And that is, Mark describes in the book that a lot of medical services in Japan are strictly regulated. There's a lot of price controls. However, Mark points out that cosmetic surgery is not regulated. There's no price controls. So we have what you see, and it's beautifully documented in Mark's book, is, as one would expect, very talented doctors going into cosmetic surgery because they can charge a price where they can recoup their investment and they get rewarded for being highly talented. And so you have this somewhat bizarre result of going from highly talented doctors going into cosmetic surgery, where maybe you would want them in cancer or something else. So a nice example of, on the Japanese side, now not beating up on the US, of a misallocation caused by the incentive structure in which doctors are operating.
Thanks, Alan. Yeah, I also liked I'm a political scientist, and I was trying to figure out why Mark asked me to be part of this panel. And I studied Japan, but not quite the way that he does. And I realized that Mark must have known that I, long ago in my past, had a traffic accident in Japan. And I was 22 years old, and I was riding my scooter in a town in rural Japan, a city in rural Japan, and I swerved to go around a big posse of high school students who were riding to school in the morning on their bicycles, and they were on the wrong side of the street. And I swerved to go around them, and paying attention to them, I went through a red light. This was right near the intersection. And a car came through the red light, and I will never forget the hood ornament right by my hip. And it took the 50cc scooter right out from under me, and I went over the handlebars, and I did a forward roll, and I came up standing. And I thought, wow, okay, must be what shock feels like. And I thought, all right, I came out of this fine, except I looked down and I had no shoes on. And that was kind of a startling thing, but it's a very vivid memory. But the even more vivid memory is how this was resolved, okay? I'm a 22-year-old English teacher. I was clearly in the wrong. I went through the red light, but I was avoiding kids to do it. And the answer is money changed hands, but none of it was mine, and I was not consulted in how it was resolved. But what it did was it created in me undying loyalty to my employer, who said, well, the guy's only been here in Japan for a couple of months. We're going to take care of this. We'll fix the guy who was driving the car, had some front end damage. I did have to pay for my own scooter, but basically I got off really easily. And that was my first experience, unfortunately one of my few experiences dealing with the legal system in Japan. So that must be why I'm here, is for that. I like the cosmetic industry example as well, but when I thought about the description of the Japanese physicians who go into cosmetic surgery, I thought that it also fit the Americans who go into cosmetic surgery. And you could find just as many people who, as Alan says, people are people and they respond to incentives. So if neither country's medical system compensates well for cosmetic surgery, but people are willing to pay outside of that system, somebody's going to take that job. I really like the book. I encourage you all to get it and to read it. As Dick said, and it's mostly right, and I think being mostly right is better and easier to achieve than being exactly right. And I say that to my kids all the time, and we say that to our graduate students: don't get it right, just get it written. And it makes sense for judges to sort of operate that way as well. The data presented is voluminous. You can really dig down into a lot of it, and if you like to mess around with elementary or maybe to second level statistics, I recommend this to you. If you don't want to do that stuff, you can still enjoy the book. I had a little bit of trouble. There is so much data presented that sometimes it's a bit overwhelming. Are we talking about claims paid versus suits filed, and the years bop all over the place? And I understand that you got to work with the data you have, Mark, and I appreciate your digging so deeply. But it also seemed like you were creating a parsimonious picture from a very irregular and inconsistent collection of data sources, and that's hard to do. But I think you did a really nice job at it. I wish that the American case, I learned a lot about American product liability law and malpractice as well from your book, but the American cases are often presented as anecdotes with names, and the Japanese are, in contrast, large data generalizations. So you mentioned this attorney named Scruggs, who I learned did the tobacco suits and then the asbestos suits, and the State Farm went after State Farm after Hurricane Katrina. And I found myself wondering, is there a Japanese counterpart to Scruggs? Is there somebody who has just made their career in Japan doing that kind of liability law? And then I also found myself thinking that in a globalized world, why were you keeping the two cases of Japan and the US so far apart? There are plenty of companies that operate in both countries. And why not have, take an approach where you could look at a company or a few companies that operate and have liability issues in both countries and see how they have responded in different legal systems? And the obvious case, because it comes out in the news today, is the Takata airbags situation. And all the automakers are dealing with this company, and all the, they're Japanese manufacturers, they're a Japanese company, and they produce here and in Japan. How are these cases being played out? And I just poked around in the news, and on the US side, we've seen 8 fatalities attributed to this product liability. On the Japanese side, we have 1 fire attributed to the airbag, but no fatalities. And that makes me wonder, this is a wide-ranging product. How can there be that difference in performance? And there's sort of a little minor alarm bell in my mind going off saying, data issue here, measurement issue here. What are we really seeing in terms of the reporting? I want to leave some time, so I'm probably just going to, the labor management, yeah, Dick covered that. I like the detail about the bureaucracy in which judges exist. I think that's a really important concept. Even as someone who studied Japan for a long time, I never really thought about the judiciary as just another segment of the big bureaucracy, but it does make some sense, and you present it so well, and it answers questions that, as a political scientist, I've vaguely had for a long time. So that's a big contribution to Japanese political studies. One place where it probably could use a little more context is, where does the judiciary stand in terms of power relative to the executive and the legislative branches? And the standard take on that is that the judiciary is much weaker than the Japanese legislative and executive branches. And yet you seem to attribute some of their, some serious policy making to the judiciary, and there's sort of a how do you explain that disconnect? And just on a purely personal, I would be interested to know, are there any bizarre product liability claims in Japan the way we find in the United States, the spilled coffee in the lap or the escalator malfunction leading to a high settlement? That kind of thing is pointed to in the U.S. as being one of the ways that America is wacky and somehow has problems, but we don't see that sort of thing anywhere in your presentation of Japan. So I'll stop there and let you respond. Thanks.
Thank you very much. Thank you for all of you. Ted asked, Dick sort of implied, why these three? I just picked my friends. So that is why you are here. And this is nice because all of you basically covered the chapters that I didn't cover, which is products liability, med mal, and then various other things like labor, and that was very nice. Ted asks, so there's too much data in it. The last book I did with an economist friend, we thought we want to sell this broadly, so we took out all the regressions and had just descriptions, and then pointed people to the articles. And the review that I remember said, this is dumbed down. Why did he take out all the important stuff? And then nobody bought it anyway. If it's not going to sell, I'm going to keep the stuff that I like in it. So that's why it's there. Thank you very much. I think part of Ted, to sort of work backwards. Part of the reason that that there aren't so many wacky cases is because you don't have juries. You have professional judges, and you get a sense like, cut this out. Come on, guys, get serious. And that does, I think, keep out the looniness that people like Dickie Scruggs do so well to introduce. He did end up in prison. Okay, but anyhow, yes, and Dick, I will have to go back and look at 1920s cases. I really didn't go back that far, so I thank you very much. Norms, of course, norms matter. You're quite right, but I guess I just haven't figured out how to study them in a sort of a falsifiable way, so I just stay away just for that reason. And then things like suicide from overwork, can we blame this on the judges? I thought it was kind of a cute idea, but you're absolutely right. It's completely unproven, and it's just incendiary. But that was the reason that it's there. So thank you very much.
So we do have time for questions, and Jim Casey here from the library has a microphone to bring around.
Thank you. It's suggested in the blurb and by some of the things you've said that there's kind of an extrajudicial settlement process at work here. Is that the case, or is it much like it is here, where parties negotiate informally with each other, and then if it gets that far, they file suit and continue to negotiate, and it's merely speeded up by the recognition that they're not going to have $1 million payday or something like that if they go all the way to court?
So how does the settlement process work? It really does all depend on what field you're in. Med mal, product liability, traffic accidents would all be slightly varied. In terms of, in some cases, as in traffic accidents, there are some institutionalized alternatives where you can go to entities set up by the insurance companies to handle this. That didn't happen, I get probably in Ted's case. And in when I got hit by a car, it didn't happen either. It was it was a hit and run, but a few hours later he showed up in my hospital room because it was an old guy, and I think his son convinced him, look, Dad, it's not good to hit people, but if you hit people and disappear, you can go to prison. And so he then turned around and came back, and he paid my hospital expenses, and he brought a box of fruit, and we contacted his insurer. It was nice of him to pay the hospital expenses, except my Harvard insurance would have paid anyway, so it did me absolutely no good. And the fruit was nice, even though I was sort of coming in and out of a coma and not terribly, not terribly helpful. But I did, since I had to leave, I contacted an attorney before I left to handle my claim against his insurance firm. I thought it was so funny because this attorney did exactly what I told my Japanese law class attorneys did, but I sort of made it up, thinking this is probably what they do, and this is exactly what he did. He pulls out this book, he says, look, your comparative fault would be X. The only thing he had wrong was he said, the other side, Lex, says that you were going 45 kilometers an hour. I said, look, that's the Tour de France speed. I'd love to go 45 miles an hour, 45 kilometers. I can't, right? But there's apparently a speed limit for bicycles in Japan, and I was over the speed limit. So I got my a very trivial amount of money and came home, and that was it.
Thank you for this talk. Having not read the book, it's,
It's not out.
So. It's hard to ask a question, but maybe that gives more freedom. So I'm curious to what extent you cover criminal law at all in the book.
No.
None at all. Okay. Then the second question is that I'm just thinking historically, as a historian, and thinking of the cases in which the Japanese judiciary has achieved prominent, like the big cases of the 20th century. And the one in the post-war that comes immediately to mind, of course, is the Matsukawa incident in 1949, in which we see this, up and down the levels of the court and this and that. And I think ultimately is a case in which the judicial system is vindicated as, of course, I guess it depends on your politics, and hence here comes the question, which is the idea about to what extent the judiciary, and Ted began to touch on this, to what extent the judiciary is accused of being or ever does act in any kind of political manner. I mean, you stress certainly that judges succeed because they're acting like bureaucrats, and that would suggest that they are politically impartial. However, I just wonder, does this become an issue that judges are trying to create law in certain kinds of cases, or if they're so bureaucratic that it's not an issue?
Yeah, no, thank you. That's not this book, but I'm happy to talk about it anyway. As you might expect, there's a political cast to bureaucratic organization in the sense that the Supreme Court is appointed by the cabinet, and the Chief Justice supervises the personnel office, and the personnel office decides who gets promoted and who doesn't. So there's clearly the potential for political manipulation. And a few years ago, a friend of mine and I, in fact, did that. We took politically prominent cases, cases that had a partisan cast, and asked what happened to judges who took positions that went against the ruling party. And the answer is they do worse. They really do worse. But that's not this book. And the reason this is not this book is that's a trivial part of what courts do. I mean, what courts are about are traffic accidents and debt collection disputes, basically. And then there are a few other sort of commercial business sorts of categories of cases, and that's the bulk of it. My guess is that, I'm making this up, but I think a majority of judges would never in their career ever see a case that had the slightest bit of political, any serious political tinge to it. The political cases get the attention, and there you do have the Japanese judiciary having being subject to political incentives, although, American politics enters American judiciary too, of course, in a different way, and we could talk about how it's different. But that's not what courts do, for the most part.
So I certainly want to read this book, which sounds wonderful. And I wanted to pick up on a point that Alan was making, and then really to ask you about culture. There are different incentives that you can create with a very tailored litigation system or one that's more generic. There are policy advantages and disadvantages to each. And so exactly how we balance those costs and benefits, well, it varies. I mean, you might look at something and say, I think we should do it this way. I might look at it and say, I think we should do it that way. But what I wanted to ask you is why you think Japan has taken has gone in one direction and the United States in another. One theory would be political economy. American political institutions are famously receptive to interest group lobbying. There are interest groups that particularly care about having it more tailored, for example, and so that might explain a difference in outcome if we think Japanese political institutions are less easy to influence that way. Or it might be some cultural explanation, or it might be something else, and I'm curious what you think.
Right, with the caveat that these are two data points, and so we tell stories about each data point. And I think the U.S. system is the way it is because of what was going on in 1770, and so we have jury trials, and we are, I think, close to being the only country that uses civil juries anymore, but we're not going to get rid of it because it would take a constitutional amendment. It's in the Constitution because in whenever it seemed like a good idea. And state judges are the bulk of our legal system, and they're selected through a whole panoply of ways, and sometimes they're subject to electoral re-election. Sometimes they're elected, sometimes they're subject to re-election, and sometimes in a very partisan way. And it's, I think, pretty hard to justify that, except that at this point we do have a bar that makes its living from them. And so this sort of becomes a path-dependent story, which I, at some level, don't like. But we've gone down this path, and it becomes very hard to move away from it. Part of this, what I'm trying to argue in this book is the Japanese system just makes a lot more sense.
Can I ask a question while we're doing this?
Answer the questions. That would be even better.
Next time. So in your product liability section, you mention, on the U.S. side, you mention a couple of cases that come from the pharmaceutical industry, in particular one, Bendectin, which is in the field of obstetrics for nausea. And the drug was pulled from the market because it might or might not have had a role in birth defects. On the Japanese side, in looking at your section on medical malpractice, there's almost no mention of obstetrics, and yet when we think about medical malpractice in this country, obstetrics is a big part of it, and so they pay some of the highest premiums. And I was sort of puzzling about this, why it doesn't obstetrics come up in, and there are lots of possibilities. But one that I had heard, I don't know if it's true, is that obstetric care, and in particular the delivery of healthy babies, is not covered by national health insurance because it is not seen as an illness. That if there are complications, those are covered. But well babies being born is not a medical care issue. Do you know if that's accurate? Or?
That's exactly right.
Okay.
Accidents and illnesses are covered by the national insurance, and well babies are not.
Okay.
So if your baby is not well, you can get it paid for by the government, which obviously skews your incentives to complain. But so why is there not as much of a discussion here? I think it's really my fault. Certainly, if you look at large recoveries in malpractice, the largest recoveries are not deaths. They are often obstetrics-related claims because a disability is just much more costly than the calculation of human life. And I think that's true here, too. But my guess is that I think obstetrics falls out of the database because it's not covered. So if it's not covered by the national insurance, then you're less likely to have the health ministry collecting it when they put together their data, and that's where I got a lot of my data. So it really is my fault, I think.
Or they're just not sharing data with you.
Oh, yeah, well, that too, but yeah.
All right, well, please join me in thanking our panel.
Thanks.